B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. Any alleged violation will be carefully evaluated, and the court will impose only those sanctions which are appropriate and proportional under the circumstances. The court will make specific findings on the record before imposing any sanction. In addition, the court may impose the following remedial measures if warranted. First, immediate suspension of video transmission of the hearing, with proceedings continuing on audio-only basis for the proceeding where the violation occurred. And disqualification, if necessary, and narrowly tailored of the news organization that filed the request in order for electronic media coverage of court proceedings for the hearing in which the violation occurred, from providing pool camera operator services in this matter, where the court determines that such a measure is required to ensure compliance with a standing decorum order and to protect the rights of the parties. Counsel will be allowed to provide their input before the court makes any final determination regarding sanctions. I want to emphasize that these measures are not intended to have a chilling effect on open and transparent courts or on responsible news gathering, and the court remains fully committed to the presumption of open proceedings under applicable rules.
Have you seen anything like this at the drugstore? No, you haven't. Look Optic is making the most beautiful readers. This is Laurel in Champagne. I'm wearing the progressive lens, which means...
What the hell? I'm pretty sure I have YouTube Prime. I guess maybe they did an in-house ad. Something tells me this is going to be a waste. I was contemplating whether even going live on the main or the second page. I was going to go live on the second, but we'll see. We'll see.
To ensure that the guidelines for today's proceedings are clear.
Yes.
Mr. Yulberg, during today's hearing, what is your primary role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd, 2025 Standing Decorum Order?
Yes, sir.
Do you understand the guidelines as they relate to your responsibilities today?
I do.
Do you need any additional time to review the December 23rd, 2025 Standing Decorum Order, or any time to reposition the camera to ensure full compliance with those guidelines?
Do I need more time? I'm sorry, was that the question?
Do you need more time to review the decorum order? And I'll pause there because that was a compound question. Sorry about that.
No, I've read it, I fully understand it, I'm good to go.
All right, to the second part, do you need any additional time to reposition the camera to ensure full compliance with those guidelines?
No, I think we're in a good position now.
All right. Mr. Yulberg, do you anticipate any difficulties complying with the December 23rd, 2025 Standing Decorum Order?
I do not anticipate any problems.
All right, and is there anything that the court can clarify to assist you?
No, I think we're good to go, sir.
All right, thank you, Mr. Yulberg.
Thank you.
Before I let you go, I'll turn to counsel based off the questions asked. I turn to you if you have any input or questions.
Nothing from the state.
Thank you.
No, Your Honor.
All right. All right. And the court, I appreciate your cooperation, and it's my hope that we all do our very best today together.
Absolutely. Thank you.
And finally, before we turn to the issue, the motion before the court, to the state, could you please provide a brief update on the status of discovery disclosure?
Yes, Your Honor. I don't have the percentage of materials that we have that have been disclosed, but I think we're above 90% at this point. There still is discovery coming in, there are reports and so forth coming in from various entities. So I think we're moving expeditiously towards completing at least this initial batch of discovery. Of course, discovery will be ongoing probably for the duration of the proceeding, but we have provided nearly all of what we have to date.
All right. And to defense, any input?
Not at this time, Your Honor.
Thank you, Ms. Nestor. All right. Thank you, counsel, for your patience as the court covered those preliminary issues. Let's turn to the defense's motion to disqualify the Utah County Attorney's Office. Ms. Nestor, or, sorry, Mr. Novak.
That's fine, Your Honor. That's okay. We actually have some preliminary things we want to discuss with respect to the posture of this motion. And I also think at some point the court needs to decide at what stage the hearing on this motion remains open and becomes closed. So I'm going to bear that in mind in terms of my preliminary statements, if I may. When we filed this motion to disqualify, and when I say we, I mean Mr. Robinson's counsel, we fully expected that what the Utah County attorneys would do is refer the motion to the Attorney General's office so that the Utah County attorneys are not in the position of representing their own interests as potentially conflicted attorneys in a potentially conflicted office, and representing the state's interest in the prosecution. We heard informally from the state's attorneys that they were preparing a response and when it would be provided. And then what we received, and again, I'm bearing in mind that we're in an open hearing at the moment, was a brief where I'm going to say the unsworn representations of two attorneys from that office are basically integrated into points and authorities. We don't have affidavits from Mr. Gray or from the other attorney. We have argument. We noted in our reply that we were surprised, that's in footnote 2 at page 4, that the Utah County attorneys were representing themselves in connection with a motion alleging that they have a conflict of interest and that the
There
state
he is. Oh my
not
God, he's
being
so
represented
handsome.
through the Attorney General's office. We did some further research on this, and you know, we have some case law that we can provide the court. I suspect that the court is very familiar with the fact, just from its own experience, that in appropriate circumstances, the Attorney General's office can either, one, represent the state in what was a county prosecution with respect to a disqualification motion so that the boundaries are clear, or if there's an ultimate finding or conclusion that there is a conflict of interest, take over the prosecution or assign it to another county. So we're very concerned that we're getting off on the wrong foot, if I can use that metaphor, because we have officers of the court who are both representing their own interests in continuing to be the prosecutors in this case and representing the state in a situation where there should be what I would call, at least temporarily, conflict counsel. I'm not sure that's the term the Attorney General uses, representing the state's interests.
Sounds like bullshit to me.
There's a Supreme Court decision which is called State v. Jimenez, Jimenez, which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the type of a case. I'm not saying that Jimenez compels that action, but it seems to me to strongly suggest that where there is a showing, I'm not sure what the threshold showing is. I don't want to say it's a prima facie showing or a reasonable concern, but where there's a showing that there very well may be a conflict of interest that hasn't been handled by a particular state attorney's, county attorney's office, that what's in the interest of the litigation, of the public, of the parties, is for the Attorney General to step in. And the citation for State v. Jimenez, if I may, is 588 P. 2nd 707. Of course, I can provide the court with the Utah citation as well. This court actually has the authority under that case, State v. Jimenez, to direct the Attorney General to step in, not for the entire case at this stage, that's not what we're saying is necessary, because that requires a finding of a conflict of interest, but to step in or to designate somebody to step in for the purposes of litigating that motion.
Okay.
And so we're very concerned that even going forward with an evidentiary hearing where members of the Utah County Attorney's Office are both litigating as representatives of the state in a prosecution and essentially defending their own propriety of proceeding in this prosecution is problematic. As far as being prepared, we're of course prepared to go forward with an evidentiary hearing, but we think that it's improvident. And we think that what the court should do if the Utah County attorneys have not or don't, if given the opportunity, do this on their own, is that the court should designate the Attorney General's office for the purpose of litigating this motion. The court might ask, hypothetically, the question, has the Utah County Attorney's Office conferred with the Attorney General about this particular question? And we are not in the dark because, as Ms. Nestor will tell the court, as an officer of the court, she's spoken with the Attorney General's office and they have not been consulted about this. Okay? So this is a motion to disqualify a county attorney's office based on what we believe is a material, significant conflict of interest that it's clear they haven't even tried to address by way of a screening, which of course is a term of art, because their position is no screening was necessary. We're not even here to discuss whether the way in which a particular attorney was screened off was adequate. Their position, as their own advocates, is we've already decided no screening is necessary. So what we've been told by the Attorney General's office, Ms. Nestor can represent to the court exactly what she was told, but basically that there has not been consultation. And while that is Mr. Gray's prerogative, we think it's wrong, and we think that this court needs to exercise its authority to intervene and say, in this case, for this kind of a motion.
That was earlier.
The court needs to hear from a representative of the state who does not even appear to have a conflict of interest. So
Comcast is so shitty. I might have to switch.
that's our preliminary statement about these issues. And again, I hope I've avoided saying anything that should have been said in a closed hearing. I think I was pretty confrontational, but I think actually what we think the court should do is the court should strike the Utah County attorney's response to our motion and direct the Attorney General to take up the responsibility for responding to our motion in whichever way clearly non-conflicted attorneys representing the state think they should, how it should be responded to. And if I've muddled, I always say this, Your Honor, if I've muddled anything or confused anything, please say so and I'll try to clarify.
Thank you. I do have some questions for you as it relates to this. I wish to consider all the authority that you wish to cite to. I mean, obviously you came into this hearing knowing that this is something you're going to present. And this court wants to be efficient with time, but thorough.
Yes.
And not jumping to conclusions. Can you give me all the authority that you wish for me to consider in considering your request today?
Yes, and I think what we could also do, which maybe would be more helpful to the court, is that we could file a short brief on this particular issue, because I will acknowledge that while we were surprised that the brief was filed by the same lawyers who are alleged to have this conflict of interest, it took us a little bit of time to, and we wanted to get that filed in time for today's hearing because the court had set the hearing. It took us a little bit of time to think through these issues. So there are Utah authorities, there are authorities from other jurisdictions, there are also ABA guidelines on the prosecutorial function, which we think strongly suggest that there should have been what I'll just call a referral to the Attorney General's office for this particular motion. I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot and require the court to, like, go back into chambers, think about it for, some pressured period of time and come back out and make a decision. So if it would benefit the court for us to file something, and I don't mean in a month, I mean very soon, so that the court has thoughtfully presented points and authorities, we're happy to do that. As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself. So I'm thinking about the convenience of witnesses and the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court is open to receiving authorities, that we recess this hearing for, whatever meets the court's schedule, whether it's a week or 2 weeks or a few days, and we can provide the court with something, and we'll come back. But we do think this is a serious issue, because I think the question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right.
Thank you.
Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that the court would be in this position based off of your request, to prepare the court, prepare opposing parties, and to be efficient in our use of time? I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what the court does.
I hear what the court's saying, and I think we can take responsibility for not sufficiently presenting the authorities that we think
Sorry about that.
compel what I've just suggested should happen. We noted in our reply brief that the county attorney should not be representing themselves. And that's probably an inadequate message to the court. But we did file a motion to disqualify. And inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflicted, appropriate prosecutorial authority, which, as I've done further research, and Mr. Byrd and Ms. Visser and Ms. Nestor and I have all done further research.
Thank you for all of the coverage at Mill.
Earlier this morning, we think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue. So I'll fall on my sword if the court thinks I should be sanctioned for not bringing this up sooner. I hear the court, but we are we're juggling many aspects of this case all at the same time, some of which the court is aware of, some of which the court probably is not aware of, but the court can imagine.
No, and I appreciate that. It's not the intent to sanction you. I understand that issues come up, and there's a lot going on, and so the court appreciates your candor and representation today. So these items can evolve, and so the court is not finding fault with you. It's just hoping that, as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party and for other parties, we just might want to make sure we make the best use of our time when we're together.
I hear everything the court is saying. I take it to heart. I understand what the court's saying, and we are cognizant of the time that the court devotes to preparation for these hearings. So that's all I can really say.
Sure. And also for Mr. Robinson himself and the victim representative, Ms. Kirk as well. We just want to do our best, and I understand, and I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happens, so I understand. I'll turn to the state. Oh, and I'm sorry, is there anything further that you wish to represent?
No, like I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court a list of verbal citations. I think with all consideration for, and we probably have, with all consideration for the fact that the court wants to be thorough and careful, and we do as well. We don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way once we understood not only the way this was developing, but, frankly, the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and the information that we received today from the Attorney General's office, which isn't a secret. It's just we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll go ahead and take those authorities right now if you'd like to list them.
Let's take it out.
Ready.
So the second one would be State v. Robertson, and that is also a Utah case, 886 P. 2nd 85. There's the ABA prosecution standards. I would refer the court to section 3.1.7 and 3.2.5. And those are, I think, the places to start.
Is there any Utah rule on point that addresses this issue?
So the case of State v. Jimenez, which I referred to, which is the Supreme Court, does actually cite a statute.
Okay. Anything further that you wish for this court to consider at this point in the proceeding as it relates to this issue?
No, and depending upon the statements of counsel, we may have some response if the court permits it.
Of course. Right. Thank you. Turning to the state, Mr. Gray.
Your Honor, I'm not sure why this is coming before us today. If it was such a surprise to them more than a week ago, I don't know why they wouldn't at least notify the court. I, too, represent the state. I'm an elected official, constitutionally elected to represent the state. Where does this end? I don't know these cases. I'm very interested to see whether or not they refer to trials. I know that the Utah Attorney General's office, they've done the same thing that we have in Rule 11 motions, where one counsel on the team examines their boss, in fact, on the matter. So I just think this is ambush and another stalling tactic to delay these proceedings. There's no reason that they could not have at least filed the motion and asked for time to brief it. And where does it end? Do we get to respond to their motion to have the Attorney General's office respond, or does the Attorney General's office have to respond to that one too? I'm not, well, anyway, I've stated my, it should have been done far earlier if that was their case, if that was their claim. And if I could just turn the time over to Ryan in case he has something else.
Thank you, Mr. Gray.
Yeah, I
Mr.
do.
McBride.
And excuse me, this is, we're tag teaming this somewhat because it's a surprise to us as it is to the court. But in the 5 minutes I've had to read Robertson and Jimenez, which could have been provided to me before this hearing, it looks like those cases don't stand for conflict of interest cases. They're actually, does the Attorney General's office have authority to prosecute cases that occur within a prosecution district or county attorney's jurisdiction? And the answer is yes. It's not about taking conflicts from the few minutes I've had to read those cases. I do want to state this is, of course, the first time this has been raised to us. The defense has known that we were going to respond to this motion for some time. We requested an extension for our filing deadline back in December. The defense agreed to that extension. Our reply was filed January 5th. The defendant's reply was filed thereafter. And in that reply, the tone of that reply is mentions that they thought that perhaps a special prosecutor would be appointed to handle the conflict case, but in the alternative says we'll be able to, we want to subpoena witnesses to establish the facts that are laid out in the state's opposition motion or memorandum. And that was what we understood was going to happen today. You have a family member of a prosecutor who has been subpoenaed. An affidavit has been supplied to the court. We believe that affidavit is adequate, but it wasn't adequate from the defense perspective, so they subpoenaed that person. Prosecutors have been subpoenaed for today's hearing. We have 2 investigators that have been subpoenaed for today's hearing. And we are ready to go, Your Honor. I think that the motion or the request the defense has made assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true. If there is a conflict, which is the question that this court is to decide, the case will be referred. Until that conflict has been established, the case is properly in the jurisdiction that has statutory authority over that offense. And until that conflict has been established, the Utah County Attorney's Office has this case and can defend its involvement in this case. I got just a moment to review my notes and see if there's other points we want to make on this.
Of course.
There is one other point I wanted to make, which is the idea that the case would be referred, that alleging a conflict would cause a special prosecutor to be appointed. That really assumes that there is a conflict, and until that conflict has been established, there is no duty for the case to be referred to another jurisdiction or another special prosecutor to handle. And it raises some of the issues that have been brought up in some of the case law regarding creating or alleging conflicts. There's a lot of case law that talks about how it can be a tactic to try and remove cases from one prosecutor's authority to find a more lenient prosecutor, find a more favorable prosecuting authority that's not going to seek, for example, in this case, the death penalty. And there's a lot of case law that talks about you can't call opposing counsel as a witness in a case unless they're absolutely necessary. And the reason is because it can be a forum shopping effort. And we're concerned with that same kind of motivation or tactic that could be used in this case or other cases like it. Anytime you, as opposing counsel, you don't like the offer you're getting, the way the prosecution is being handled, you allege a conflict of interest, and all of a sudden the county attorney's office has to spend $10,000 to hire a special prosecutor just to handle that one issue, regardless of whether or not it's supported or whether or not a conflict exists. That's a concern we have. Your Honor, we're ready to go forward today. We think the evidence that will be presented today will illuminate the issues adequate that Your Honor can make a decision about whether or not a conflict exists, and we don't need to delay this proceeding any further. We're confident the court will see the facts as they are and be able to make that determination.
Mr. McBride, so the motion has been made by defense to continue this hearing to allow the filing of a motion addressing more fully this issue. And to that request, what is the state's reply?
We object to that motion to continue or to strike. We ask the court to go forward today. We think the motion is untimely. The court has, or the prosecution has subpoenaed witnesses, and every delay that happens, the witnesses that we have now family members of the prosecution being subpoenaed. These people are ready to move forward and get this out of the way. The longer we delay this, the more anxiety that this procedure has.
All right, thank you, Mr. McBride. To defense, any response?
Yes, John, thank you. First, I want to say this is not about seeking a lenient prosecutor. This is not about tactics at all. And it was actually the county attorney's office who informed us back in October that there was a family member of a prosecutor who was present.
At this point, you're probably not avoiding therapy because of stigma. You're probably avoiding therapy because you've become very good at coping. So good that you stop noticing how heavy everything feels. As a therapist who goes to therapy herself, it's important to remember that your mind and body hold on to every stressor you don't have time to.
Tactic. The Utah County Attorney's Office informed us in late October that we needed to know about this, and we informed them, fine, that's your position, it's not a conflict of interest. We think it is, and we intend to litigate it. So it's not a tactic, it's not something that we've made up out of whole cloth because, like I said, we found a needle in a haystack. It's something that they properly brought to our attention, but we firmly believe that the law supports the conclusion that that particular prosecutor should have been screened off. There's good case law on screening, which we did fully cite in our briefs in a timely way, and there was no effort to screen off that prosecutor, and that has now created a problem for the whole office. That is not made up out of whole cloth, and like I said, it's not about tactics or lenience or delay. This isn't delaying anything, at least on our part. The other thing that I want to point out is to say that until this court decides there's a conflict of interest, somebody else shouldn't be handling this issue is circular. Because by that point in time, the court would have already allowed the conflicted attorneys to represent the state in a hearing on their potential conflict. So I actually think the way you avoid that circular argument and the sort of harm that arises if the court were to find that there is a conflict is to at least temporarily have the Attorney General's office handle this. Yes, Mr. Gray is an elected official, but that doesn't mean that his office doesn't have a conflict of interest. Conflict of interests arise. A judicial officer decides to become a prosecutor. A prosecutor decides to become a judicial officer. That's actually where most of the case law comes from, as Your Honor knows. A defense attorney changes careers and becomes a prosecutor. There has to be a screening. The case law is very clear that the screening has to be adequate. There's been no screening here because Mr. Gray decided we don't think there's a conflict of interest. And what we're saying is it's not a needle in a haystack, it's not a tactic, it's not a fiction, it's not a thin reed. The evidence that the court has suggests, number one, that there's a very good possibility that as a legal matter there's a conflict of interest. That's why we need to have an evidentiary hearing, because the court doesn't have all the facts. And number two, that the Utah County Attorney's Office, because they decided early on, without consulting with anybody, that they didn't have a conflict of interest, didn't put any screening mechanisms in place. And so I understand that they want to defend the decisions that they've made, but the question is, shouldn't the state be represented by somebody else in the course of this court resolving whether those decisions were right? Because to quote the law and to quote the ethics, the Utah County Attorney's Office is now serving two masters. I don't like that word, but that's the word in the doctrine. They're representing themselves and they're representing the state of Utah. And that's why the Attorney General or somebody else designated by the Attorney General should be representing them in this matter. And I do want to say one more thing, if I may, Your Honor, and I appreciate the court's patience. I think that the way we raise this issue in our reply brief is not as accommodating to just letting it go as counsel suggests. What we said is we asked the question is whether it is even appropriate for the UCAO to litigate this issue on its own behalf. While the UCAO may have provided this court with the information that it has deemed relevant to this issue, the scope of the disclosures and litigation of this motion should have been assigned to another state agency, such as the Attorney General. We didn't suggest that this court should appoint a special prosecutor for all purposes, or that the filing of this motion means that the Utah County Attorney's Office is automatically disqualified from the litigation. That's the point of the motion, is whether they had a conflict of interest, and if they did, whether they handled it. And it's our position, correctly, and it's our position that the answer is yes and no. So I understand there are witnesses here, people are ready to go. We think that the court should either accept briefing or agree with us that the referral is appropriate. And I want to cite, if I may, the citation by the Supreme Court in Jimenez. So this is 588 P. 2nd. It's 707, but this is at 708. This is the statute quoted by the Supreme Court. If at any time, after investigation by and a finding and a recommendation from the district judge involved, that the county attorney in any county is unable to satisfactorily and adequately perform his duties in prosecuting a criminal case without additional legal assistance, the Attorney General shall provide such assistance. That's very broad. What that means in this case is it's inappropriate for the Utah County Attorney's Office to represent itself when it is also representing the state. And that for this motion, this court has the discretion, we would say, respectfully the obligation, to designate the Attorney General to represent the state, the people of the state of Utah, in this motion. And depending upon how the court rules on the motion, then we have to see what happens next.
So is it your position that the court has discretion to make that decision?
I think that the court has the discretion to say to the Utah County attorneys, you shouldn't be representing yourself in this case at this stage as to this motion only. Continue to do what you do while this motion is pending, and we will resolve this motion. I am not suggesting that they should stop the work that Mr. McBride talked about preparing discovery, having their agents interview witnesses. We want to get this motion resolved in a timely way. It is not a stalling tactic, but I'm not saying, let me be very careful because I don't want to misinterpret the court's question. I'm not saying that whatever this court decides is the right decision because the court has discretion. We believe that the law requires that the county attorney's office be represented by somebody else for this motion. What I'm saying is the legislature gave the court the authority to compel that when the state attorney and the attorney general haven't done anything about that yet. I'm not saying that the court, I mean, I don't know what the standard of review on appeal would be, so I'm not just saying it's an abuse of discretion standard. What I'm saying is the legislature gave this court the authority to direct, refer to the attorney general representation in a criminal case where there's a showing of a potential conflict of interest. And I've been a criminal litigator, although on this side for a long time, so I understand what counsel's talking about is sometimes defendants come up with questionable grounds and move to disqualify. And I don't think that that's a finding that the court can make in this case. It was actually, as I said before, the Utah County attorneys who were concerned about this enough that they brought it to our attention. We have profound disagreements about the significance of the conflict and the way it was handled. Okay, and otherwise, I think I would be repeating myself if I said anything more without answering a direct question.
All right, I just have a brief question. Do you have your witnesses here today?
All the witnesses are here. We have no problem as a pragmatic issue going forward. Our witnesses are the subpoenas that we served, which were filed with the court. So to be clear, I don't think the court is inferring this. We're not unable to proceed if that was the court's conclusion. We are prepared, and the witnesses are here. I'm just saying we think that it would be improvident and it could result in errors of law, and it could result in problems down the road.
Thank you. Do you need any additional time in regards to your argument to continue this hearing based off the citations you've provided, the authorities you've provided the court?
1 second.
I know this is crazy, but I feel like the judge is ready to give a prostate exam. I feel like I don't know, it's crazy. I know it's crazy, but I just feel like there's something about him that just feels like, you want to bend over and I can examine your anus? I don't know why. Just something about it is weird.
This is an important issue.
Tripping.
The totality of what's
It's like so soft-spoken.
And my question in regards to your witnesses was informatory.
I'm tripping. Maybe I'm tripping.
See if depending on what the court rules, if the parties, I don't want to disadvantage either party in that. So this is an important issue, and this court wishes to take a brief recess. I want to look at what's been provided.
They're going to take a brief recess. Let me tell you guys, if you guys could help me out on Twitter, because honestly, I'm done with Comcast. I'm done with Comcast. I'm done with their bullshit. If you could boost this post, if you have X, if you could boost this post, because their service has been shitty and unreliable. It doesn't work. And if they try to upsell you like they do every time on business, let's say your residential service sucks, they'll try to upsell you. Oh, get the Comcast business. Do you know that they're plugging your same shit into the same service that everybody else in the residential area is using? Comcast is a scam. And it's bullshit. And I've been dealing with them for months, and I'm done with this situation. I'm done. And I have receipts, I have screenshots, I have videos. So not only do I want to cancel the service, which I text the corporate. Look, it's to the point where I know somebody in corporate and I can text them and call them, which I did. I know the local supervisor for my city. I texted and called him. And yesterday, the supervisor told me, hey, we're going to send somebody to your house. Are you going to be available? I said, yes. He didn't tell me a specific time. So I made my whole day open for these pieces of shit. They never showed up. These people didn't show up. So for now, what I told the corporate person and I told the supervisor, I want a refund because T-Mobile and Starlink together is providing a better service. Wireless. These are wireless. They're not even, it's not wired. Starlink is on the roof of this fucking building connecting to a satellite. T-Mobile is in my backyard, pointed. It's a 5G thing pointed to like whatever. Those two are getting better service than the shitty service that Comcast is providing. So I'm done. So I want my service canceled, as I've told these guys. Not only that, don't give me a cancellation fee. And I also want several months refund because you guys have not provided the service you say you're going to provide. And if you can't do that, give me the legal contact because that's the next step. We're going to get lawyers involved. The next step is getting lawyers involved for the fraudulent service you guys provide. And I've done it before. I don't want to have to do that. I don't want to have to, because it's money and all this shit. But if we have to do that, because right now, what kind of person has 3 internet service providers in their house? Literally, I have Comcast, which is a piece of shit, T-Mobile in the backyard, and Starlink in the front. I have 3 internet service providers. What kind of wild shit is that? So if you could boost that post, I'd appreciate it, whether it gets their attention or not. Cancel my shit. Put me in contact with the legal department because I'm going to get a lawyer at this point if you're not going to meet my demands, which is no cancellation fee. I'd be happy with like 2 or 3 months refund. A refund, because at this point, I can get the residential service. It's a scam. I'm telling you, most people don't know this. It's a scam. Oh, get the business Comcast. They put you in the same node with residential, and then they say, "Oh, it's different. You're getting some superior service." You're not. So I'm done. I'm completely done with these people. That's it. If we got to get lawyers, we got to get lawyers, and that's it. I'm done with these fucking people. Call the UN. I'm ready to take it to the next level because these people have tortured me and harassed me for decades. At my mother's house, and I moved to a different place and I had AT&T. That's when I realized how bad Comcast is, and then I came back over here, and it's just really bad, really, really bad service. So I'm done. I'm done being nice. I'm done being fucking kind with these people. All this bullshit they put me through, I'm done. Cancel the shit. Cancel the fucking thing. I'm done. Take your shitty modem that's rented. Take that shitty modem over there. Take that thing back. Cancel the fucking service. And I'm done. Done. Because most people, this is what these corporations bank on. Most people, your mother, your father, blah blah blah, they're watching Netflix. They're doing a Google search. They're watching a YouTube video. So most people have no idea they're being ripped off for what they're paying for, unless you're streaming like me. So that's the next step. Give me the refunds that I want, or we're gonna get lawyers involved, and we'll do it that way too. That's fine. And I'm brown. I'll use racism. I'll use whatever I have to use to my advantage. You guys being racist, whatever I gotta do. I'm joking, but yeah. So I'm done. I told them to cancel it because honestly, you know what I'm realizing? The last couple of days, I've been testing out Starlink and T-Mobile, and the internet's been fine. For the most part, it's been smooth. And I'm like, why am I wasting my time with Comcast? It's literally hardwired into the ground, and they can't keep up. I want them to answer the fucking phone. I'm just pissed off because I'm so done with this shit. Let me call this guy. Not answer. It's going straight to voicemail now. maybe they just blocked my number. I don't know. Play the end card, bro. That's so funny that now it goes to voicemail. Look, listen. Let me show you that.
This is Miguel from Comcast Business, Corporate Escalations. If you are calling regarding an active corporate escalation, please provide your ESL number.
I had little direct contacts with these people. I don't want to shit on these people because I still feel like, I don't know if this is beyond their pay grade. And they literally watch my channel. That's the odd thing. They told me they're watching my shit. Like one of the guys was like, "Yo, are you having problems now? Because I saw you were streaming." And I don't know if it's political too. Sometimes I wonder, it's like I'm streaming this ICE stuff and I don't know if these Comcast liberals, they're watching my shit and they feel some kind of way. I've thought about that too. I know it's like maybe it's too much, but I have thought about that. That's why I was like, maybe I got to get off Comcast, these liberal fucks. Like I have to move on. Because they'd be like, "Oh, everything's fine." I'm like, no, everything's not fine. I've documented, I've recorded it. I have multiple screenshots of it. That's what I'm saying. If we have to go civil, I have no problem with it because I've recorded so many instances of this shit. It's ridiculous. So I don't know what's going on anymore. We can see your stream, sir. I know it's unfortunate, but I'm just done. And I'm on like in a dead zone area, so there's not much I can do, I guess. But whatever. If I gotta take AT&T, Starlink, and I have T-Mobile and Starlink and Comcast. If I have to take AT&T and fuck over Comcast, that's what I do. I'd rather pay somebody else that actually provides the service they say they're gonna provide. You know what I mean? It's like, I know it's crazy, but I'd rather pay somebody else. So we're done. We are done. Cancel the shit and refund me my money. That's all I want. And send me your legal contact. I want your legal department. I want the contact for that legal department. That's all. Because I'll spend the money on it. Fuck it. I've been spending money on you guys for months and years and shit. I'll do it again. All right. Oh shit, he went crazy. He went nuts. That guy on YouTube. I'm done. So yeah, if you could boost that post, I'd appreciate it because that's just the level before, I don't know. If they cancel the shit, no cancellation fee, and refund me 2 to 3 months, we part ways and we don't have to go legal. We part ways and we move on. That's it. But if you're not going to do that, and I know they have more money than me, but that's fine. I'll take it legal. I did that with the other cocksucker. I'll take it legal if I have to because the other cocksucker paid me out. I have the check and picture of that. I never posted that. That's in my arsenal and in my whatever. If I have to do that, I'll do that too, but I'm not there yet. So if I have to do that because I've been there, we'll do that. I don't want to have to go there. So refund me my shit, cancel my shit, and we move on and be done. That's it. But I've literally had them say that they watch my stuff. So it's like, I don't know. Could it be the political stuff? Could it be somebody in India watching my shit and be, oh, he's talking about deportations? We're going to push the button, Bloop. Cause problems. I really have thought about that too. Like, are they watching my stuff? And it's like, bloop. Somebody, he literally, I can show you. Hold on. I'm not gonna go all out now, but I'm just saying that Rest of that. I don't know where it's at. I don't know. I guess we'll see. Maybe they'll make it right and just give me the refund and I move on. You know, we'll. I guess we'll see. Yeah, AT&T fiber is pretty good. Yeah. Yeah. Oh God, my camera overheated. They offered me the air option. It's not good, right? I thought about getting the air. I don't know, man. The air option is just 5G. I'm gonna turn on the fan for the camera. It's just 5G. That's all it is. It's like a 5G option. There's not many options. If you can get AT&T fiber, that's the best. If your cameras are in security or connected to Comcast, will screw with yo. Yeah, I've had to disconnect my cameras outside from Comcast because Comcast is always a piece of shit. So I connected it to my other internet and it's working fine now. Watch out for this venting session. He about to call Monday to make good. I'm not calling any of these people to make good. They need to call me and make good. If they call me and make it good, then I'll be quiet and I'll move on. But if they don't make it good, then we're done. And honestly, I would advertise. I literally would advertise how shitty their service was because I'm so petty. Their service is so shitty that I would make a video and pay for advertisement to promote that video. I would do that to warn other people. All right. It's Friday. Let me calm down, relax. Life is good. You know, there's people in other countries that don't have internet. Maybe I'll have to stream in 1080 like all these other petty YouTubers and news broadcasters. You know what I realized with these news stations? They all have shitty quality. They don't even make an effort. You notice that 720, 1080, and it's like shitty quality? Maybe I'll have to reduce myself to these people that don't take pride. Media companies that don't take pride in the quality of the stuff, you know? I don't know. This shit looks like Nintendo. And most people can't tell. If you're watching it on your phone, you can't tell. But if you put it on your big screen, you'll tell. I'll try to turn on the camera now. Hey, Melvin, we got your message. Okay, we're going to work on it. We're going to send somebody out. What's not turning on? Okay, there we go. I guess what else can we watch while we wait? I almost wasn't going to stream this because I know it's like a waste of time with these people, but oh my God. Damn, yo, Ashley St. Clair. She's going like on a world press tour. I guess this is Elon Musk's baby mama, I guess, on a world tour because she wants to destroy this guy. Oh my God, dude. That's what I told one of my friends. Like, you be careful who you have kids with because they will literally, especially as a man, they will try to, if you're not getting along, they will try to destroy you. This chick, knowing that Elon has like a trans kid, had like apparently sided with trans kids recently just to fuck with him. And like people on X are saying that like she's alluding to like she's going to make her kid with him trans too. Because that's how evil, decrepit people are. And some of these women, not all of them, but some of these women, they'll use the only thing that they can use to get to you, which is the kids. Like liberals. They will literally indoctrinate, manipulate, and use children to get their point across.
Put your face out here like you are now.
Because it's not just about me. It's about building systems and AI systems which can produce at scale and abuse women and children without repercussions. And there's really no consequences for what's happening right now. They are not taking any measures to stop this behavior at scale. They are saying we're going to make it illegal where it's illegal. That is absent all morality. And guess what? If you
And her argument is that all of a sudden she cares about AI and Grok. And her membership, her premium blue check mark on X was removed. And so now she's arguing that Grok shouldn't turn people naked, which I agree. Like if you put a picture in or if there's people putting pictures of kids and they're like, make this child naked, they shouldn't do that. That's wrong. I agree with that. But you know that this scorned woman, the only reason she's speaking is because he's thrown her to the side.
You have to add safety after harm. That is not safety at all. That is simply damage control, and that's what they're doing right now.
Because you can't even get them removed. Once it lives, it lives. All right, so Elon Musk has posted on X this week about you, right? Obviously, you're out talking about this and trying to raise awareness for this. He posted about you, I'll be filing for full custody today, given her statements implying that she might transition a 1-year-old boy. Now, she's, I believe, talking about your child. Obviously, did not imply that in the post that you posted that he's responding to, which I want to read to everybody so they can hear it for themselves. You are apologizing for past comments that you'd made about the transgender community. You wrote, I feel immense guilt for my role.
So all of a sudden she's taking all this back because she wants to take shots, and now she has control of his kid.
And even more guilt that things I have said in the past.
Unless she's always felt like that and she was fraudulent and just acquiesced to him, you know, like, oh yeah, I'm against this, I'm against that, you know, let's have kids together. And so he pumped one in her. Elon's messing up. Elon, the truth is, Elon, in my opinion, is impregnating all these women. And he has all these baby mamas, and it's kind of careless. You know, but at the same time, like Nick Fuentes complaining that he's saying, oh, the white people, genocide, there's not enough white people, but he's a virgin, never had sex, not married, and all this stuff. So it's like, you know, I
may have caused my son's sister more pain. Your son's sister is another one of Musk's children who has transitioned. What's your response when that's the post this week?
I'm not at liberty to discuss it further, but I think anyone with more than a third grade reading comprehension level knows what I was saying there.
Yeah, I mean, I guess I have so many questions to ask you, and I know that you're not at liberty to talk about things like custody and that, but I guess I'm curious.
His African American, his African American side is coming out. Maybe. Or he's Mexican. You know, white supremacist, he's Mexican. You know what I think would happen to Nick Fuentes? He should be careful, because I think the moment that guy got P, if he ever gets it in his life, he would lose his mind. He waited till he's like 30. He's almost 30. He's never had sex. The moment he gets that shit, he's locked in. His whole life has changed. He's done. Unless he's not into that, he's into men, which they say he's already had multiple times. But that could be the case too. Nothing wrong with that if he's into that, but that could be the case too. He might be into pussy, not the other one, you know?
In all of this, how hard it must be for you. I mean, do you want your child to have a relationship with his father?
I cannot discuss that right
now. You can't even talk about that. So I guess in the context of this, what do you do now?
I'd like to keep the focus on this issue at hand, because I think there's a lot of people, especially with very tabloidy tweets, that are trying to distract from this issue, because it is a big issue. They are facing immense backlash from multiple countries, and they are trying to move something to the second page of Google because they want it to go away. And I don't think we should make it go away. I think this needs to stay center focus until there is regulations and protections and safety for people being abused by these very new platforms, these new technologies. And you can't brag and take credit for being a disruptor in an industry and then absolve yourself of all liability once this damage and harm is done.
All right. Well, Ashley, thank you very much. I appreciate
Ashley. Sometimes you get those. Like the other chicks, they fall in line. They're respectful. They're getting that money. But then you get a wild chick, a wild card sometimes, and you don't know how they're going to act, you know? And that's what's happening. Ashley St. Clair, the thoughty, he fucked up. Elon Musk messed up, man. Let me see what else there is. We might have to come back for this. I don't know. They feel like this prolonged. The judge was kind of weird to me. I don't know what's going on with this. All I know is that the last times I've watched this, it's been like a waste of time. It feels like they're not ready to have a trial. When you're ready, call me. Just like Koberger. They were playing all these games, Brian Kober, all this shit. I tuned out. Call me when you're ready for the trial. And that never happened. Call me when you're ready for the trial. All these games, all this whatever, and it's nothing, a nothing burger. Let's see. Oh my God. All right, yeah, I think I'm gonna come back. I mean, I don't know what's going on. Tommy's out. Was he locked up? What happened to Tommy? Tommy. What? Pull up TKO Tommy. I pulled up his page. I don't see anything. Tommy Boy, right? I don't see anything. TKO. Oh no, I don't see anything.